Court is ready to hear argument in 1945, AEP Texas Central versus Arredondo from Brooks County and the Fourth Court of Appeals District.
May it please the court, Ms. McCormick and Mr. Shepard will present argument for petitioners. Petitioners have reserved 4 minutes for rebuttal. Mr. Shepard will open with the first 8 minutes and Ms. McCormick will present the rebuttal.
May it please the court. We represent T&D Solutions in this appeal, Your Honors, and this case involves a stub pole that was removed from the ground by T&D Solutions, which resulted in the hole being backfilled after T&D Solutions completed the job. And here, the Court of Appeals in Corpus Christi erred because the summary judgment evidence and the arguments establishing that T&D Solutions properly filled the subject hole with dirt after extracting the pole was not considered by the Court of Appeals. And this changes the entire analysis in the Court of Appeals, Your Honors. The summary judgment evidence conclusively establishes that T&D Solutions filled the hole, and it's uncontroverted by the respondent in this case. And just a brief background here.
Excuse me, let me just ask you a question about that, because the record was a little bit confusing to me on that, because I've read on one hand that the parties are agreeing that the hole was filled in, but on the other hand, they've also said that when they went back, the hole that was there looked like it was a hole that had been left by the pole. So how do those two fit together?
Yes, and the issue here is that there was almost an 8-month gap between the time in December that the pole was removed and that the hole was filled. Fast forward to July, and we have this gap there. So the evidence showed at the summary judgment stage and by uncontroverted testimony of T&D Solutions witnesses that the hole was in fact filled immediately following the stub pole being removed from the ground.
So is there any evidence that that hole was filled with something like sand or something that could have washed away?
It was in fact filled with dirt. That was what the evidence showed. And TechServe, who was not a party to this appeal in the Supreme Court, but was a party to the appeal in the Court of Appeals, was the company hired by AEP to backstop T&D Solutions to make sure after T&D Solutions completed the work that T&D Solutions had actually done the job. So TechServe checked off their box after going to the property and confirming that the work was done. So here we have a situation which is inconsistent at best by the Court of Appeals, because if TechServe says T&D completed the job and the Court of Appeals says T&D Solutions did not complete the job, then why did the Court of Appeals affirm summary judgment as to TechServe, but who is the downstream defendant, but did not affirm summary judgment as to T&D Solutions? So here we have an issue of the inconsistency there, but also as part of this, the summary judgment evidence is clear that we address the issue of the hole being filled, which if we filled the hole, there is no breach. And the cases relied upon both by the Supreme Court, or excuse me, by the Court of Appeals and by Respondents' Counsel are distinguishable. In the Court of Appeals relied on the Stoller versus Service Corp International case erroneously. Unlike the service company in Stoller, T&D Solutions did address the respondent's negligence claim and repeatedly discussed the fact that T&D Solutions did in fact fill the hole, which addresses the element of breach. And the respondents want to argue that we didn't necessarily address the element of breach, but that's not accurate. We address it throughout the motion for summary judgment. We also address it in the briefing on appeal. And in the in the case of Deere versus City of Irving, the Austin Court of Appeals said that if the motion for summary judgment contains a concise statement that provides fair notice of the claim involved to the non-movement, the grounds for summary judgment are sufficiently specific. And here, that's exactly what happened. The Stoller
If
case.
the plaintiff says that she fell into a utility-sized hole, and that hole wasn't evident because it took a while for the hole to be removed, and then there was overgrowth, is that evidence that creates a fact issue as to breach, assuming that you've challenged breach? In other words, you say that the hole was filled, but do we have controverting evidence that the hole wasn't filled? And so at that point, isn't summary judgment improper?
It's not, because what the plaintiff, the respondent here, argued is that she did in fact step in a hole. The evidence that was before the trial court was that the hole was in fact filled, which that part was uncontroverted, and that the TechServe company came behind and confirmed that the work was done. The only evidence out there is that she stepped in a hole 8 months after the last time that anybody was out at the property, whether it was T&D Solutions, TechServe, or somebody else in between. There's no evidence whatsoever what hole it was that she stepped in. There was no evidence that the hole was related to the pole that T&D Solutions removed. And so,
Mr. Shepard, was there conclusive evidence that the hole was filled properly in terms of compacting and that sort of thing so that the dirt wouldn't settle? And if not, why isn't there a fact issue? I mean, why does just showing that it was filled conclusively establish that it was filled properly?
There was no evidence in the record by the respondent, the plaintiff in the trial court, that if in fact it was filled, which we say it was, that it wasn't filled properly.
Except
and so
there was a hole there that she stepped in.
Well, and the evidence showed that our side of the evidence showed that it was in fact filled. But what plaintiff alleges is that she stepped in a hole that was near the hole that was left by the stub pole. But all the evidence shifted to the fact that the hole was in fact filled. The evidence showed that it was filled, and by filling the hole, it does not create a breach. And here, one of the issues was that there was a negligence, that this was a negligence claim, not a premises liability claim. But because the evidence showed that the hole was in fact filled, that relieves a duty, and it does not have a dangerous condition on the property. And that's the issue raised by the plaintiff, the respondent here, in the Strakos case.
Mr. Shepard?
Yes.
I think the question that we're struggling with is mere evidence, even conclusive evidence that the hole was filled, you say negates breach as a matter of law. And what we're saying is, what if the evidence conclusively or otherwise established that it was filled, but not properly filled? I mean, if they filled it with powdered sugar that, within 10 minutes is going to have settled down to the bottom and the hole's back, isn't that a breach? Wouldn't that be a breach if they filled it improperly?
Yes, sir. And our position is that T&D did not breach, and that issue was not addressed by the respondent in the trial court. If there was in fact subsidence or anything else that could have occurred, that issue was not raised in the trial court by the plaintiff. There was no question raised by the
burden, Mr. Shepard, to raise it on summary judgment, right? It's your burden to prove conclusively that it was filled properly. Isn't that right?
Well, and with the fact that it was in fact filled, that relieves us of any breach. And that's the...
Well, that's the exact statement that I'm saying we're not understanding. You're saying because it was filled, you couldn't have breached. And we're saying is, well, if you filled it improperly, couldn't you have breached?
And because it was because it was filled, that's what, and our position is that there was no breach because it was in fact filled. Whether it was filled properly or improperly was not an issue raised by either side in the trial court.
Any other questions?
I just have one question that's a little bit different issue, but this is a very unusual case with regard to the premises liability aspect of the case, because the plaintiff here is the property owner. So what impact does that have? I mean, how can you be an invitee, a licensee, a trespasser when it's your own property? So we can't even get into the things that you would typically get into in a premises liability case.
Well, and here, Judge, the issue is because there was an easement and it was a utility easement.
I understand how AEP is the owner, but that doesn't resolve the question about the plaintiff who was injured on her own property.
Oh, and it's a premises liability case as to the easement. Although it's her property, it's a premises liability case as to the easement.
Do you have authority for other cases who have dealt with it in this context? Because this is unusual.
It is unusual, and one of the cases that, and frankly, the Strakos case talks about the issue of poles being removed from the ground, and even Strakos does not address the issue of the utility company easement being on someone's property and how that creates a premises case. But our position is that it does, and I think the law going toward that condition on the property.
Perhaps in a commission type of memo, you could provide us with some authority for that.
We can do that if the court would like. Yes, ma'am.
Any other questions? Thank you, Mr. Shepard.
Thank you.
Ms. McCormick, we'll hear from you.
Good morning, may it please the court. I'm here representing AEP Texas Central Company and will address the issues that AEP brings. Those are wholly independent of the one that T&D just presented. AEP's issues concern the existence, nature, and scope of the duty that Arredondo says AEP has. In three distinct ways, the Court of Appeals has erroneously and dramatically expanded the potential liability a premises occupier and general contractor has for work undertaken solely by an independent contractor. First, the court recognized a duty based on common general contract provisions that don't dictate the operative details of how work is done. Under binding precedent, there's no duty in this circumstance. Second, the court refused to apply principles of premises liability to Arredondo's retained control claim, even though Arredondo expressly alleged she was injured by a defective condition on premises occupied by AEP. And third, the court incorrectly assumed that AEP may be held liable without any evidence that AEP itself was negligent. The court failed to acknowledge that retained control liability is not traditional respondeat superior liability, but is instead for the negligence of the general contractor itself.
Ms. McCormick, what discretion did AEP retain under this contract to fill, not fill, fill with sugar, that sort of thing? What type of discretion did it retain under the contract language?
So under the contract language, let me set some context here. The contract is in the record and attached to the brief, and this contract was not specific to this job. It was actually a master agreement that governed the relationship between AEP and T&D for all system construction work that AEP needed across a wide geographic area. There are several provisions in this contract that confirm that AEP did not retain discretion over this type of work, and that T&D was responsible for directing all of the work and choosing the safe methods for executing the work. The contract expressly deemed T&D to be an independent contractor, and section 4.1 of the contract said T&D will be solely responsible for the supervision, direction, and control of its employees. Section 2.5 required T&D to have qualified and competent supervision at the site at all times to direct and observe the work. And Section 7.1 required T&D to use such safety devices and methods as are necessary to protect the public from bodily injury and property damage. So these provisions were an allocation of responsibility and discretion, and they were part of the bargain that the parties struck when they entered into this agreement.
Did you, excuse me, did you retain any control over the means or the method or the details, and what does that mean? I think that's in the contract. What effect should we give that language?
So there's nothing in the contract that actually retains control for AEP over how T&D did this task. The provisions that I just outlined in general make clear that T&D is responsible for how the work is done. Now, there may be other types of tasks that were done under this contract in other locations, like work on live wires, things like, or electrical work. AEP does, the contract does have provisions in it that may dictate how T&D did some of that work, but for this type of work, there is no provision that retains discretionary control over means, methods, and details of how the job was done. Now, the Court of
does the provision that says that T&D has to have an authorized representative to whom AEP may give instructions at all times, how should we read that? It doesn't seem to be limited to a particular type of work.
That's right. That's the primary provision that the Court of Appeals relied on. And the court read that provision in isolation without reference to the provisions that I just outlined. That provision is Section 2.4 of the main contract, and it just enables AEP to communicate efficiently with its contractor when work is taking place. And that's important because many of the projects contemplated by the agreement, for example, storm restoration, require frequent communication and coordination about what actually needs to be done. Every general contractor needs to be able to do this, but the provision doesn't keep T&D from doing its work in its own way. On its face, the provision doesn't control anything about how T&D performs any particular task. And under the law, liability can only be based on a contract provision that itself ties the subcontractor's hands in a way that contributes to the alleged injury.
But didn't AEP have the right to control the means and method?
No, Your Honor. No, we would disagree with that because the provisions that I outlined at the beginning of my argument, Section 4.1, 2.5, and 7.1, make clear that T&D gets to control its employees and the methods that are used to accomplish work like this. And there's nothing in the contract that contradicts those provisions for the type of work that was done and is at issue in this case.
You said, Ms. McCormick, that the Court of Appeals erred in reversing because there's no evidence that AEP exercised any right under the contract. But did we say in Dow Chemical that if the contract does allocate the details of the work to the general contractor, there doesn't need to be evidence that the contractor exercised that right under the contract? And so how would we distinguish that if evidence is required of performance of those details?
So this case doesn't involve any allegation that AEP controlled by its conduct. There was no actual activity by AEP on this job. So the Court of Appeals found a duty based solely on the contract provision. And the law is that when you base liability or recognize a duty based on a contract provision, the contract has to be very specific and must, on its face, dictate the manner, means, and operative details of the task. And this requirement of specificity is confirmed in many cases from this court, where the court says the contract provision must explicitly assign control to give rise to a duty. That's the court's word. And there are very few instances in which this court has recognized a retained control duty arising from a contract provision. There's the vacuum cleaner case and the Celanese case where A-frame ladders were, you couldn't use an A-frame ladder in a certain way. Those are very specific contract provisions. They're fundamentally different from the one that we have here. And very close to the one in Victoria Electric where there was held to be no duty.
Any other questions? Thank you, Ms. McCormick. We'll hear from the respondent.
Good morning, Your Honors. I would like to first address some of the issues with regard to the T&D summary judgment. And our position with regard to that is that T&D, under a traditional motion, had the duty to conclusively establish its elements. And they attempted to do so by saying that there was no dispute in the motion for summary judgment about whether that hole was filled. And I don't agree with that, Your Honors. I think that specific fact was disputed. I think that the evidence shows that the hole that Ms. Arredondo fell in was the same size, the same shape, and in the location where that first pole was removed. And at that point, the summary judgment law says that if there's contradictory evidence, that you can't consider the issue that T&D raised that it filled the hole. And at that point, the question is whether or not there's a fact issue. And applying summary judgment law, if you're going to, favor the respondent in all matters of fact and all reasonable inferences, then a summary judgment issue should have been created and was created. And the trial court wrongly granted summary judgment when the issue should go to a jury. And the jury is simply going to decide whether or not the hole was filled or not. And that's a fact issue specifically for a jury.
For summary judgment purposes, is it enough to just say there was a hole and it was not filled, or should you have said more? Because what if there was 5 holes, around, and only one obviously can be the hole that, and so what did you have to do more other than say, well, there was a hole and it wasn't filled? I mean, is that enough to raise that fact issue? Or should there have been a little more to connect it to, the actual conduct?
Well, Your Honor, the summary judgment standard is whether or not, given the evidence that's presented, could reasonable minds disagree about what that fact issue was. And so if one side says we filled the hole and someone signed off on us filling the hole, and the other side says, no, there was a hole there where you left your pole, and that hole was the same size and shape. And I believe that the record does include, although I don't think the detail is very good, the record does include, pictures of the hole that was filled. And the testimony from the witnesses, from the employees who went out there to fill the hole, said that looks like a pole, that looks like the type of hole that would be caused when you remove a utility pole.
So enough to raise a fact issue to simply say there was a hole and it was similar, and so that should create a fact issue.
Yes, Your Honor, I believe so. And if that's a fact issue, then summary judgment wasn't proper and it needs to be tried before the trial court. With regard to AEP, I think the justices have done a good job of highlighting the provisions that I think the Court of Appeals looked at, and that I think that the Court of Appeals showed that contractual control could be exercised. Specifically with regard to the on-site personnel on the job, that on-site personnel had the authority to give instructions and to make changes in the way that the means and method of that job was done. Additionally, while Ms. McCormick, while the petitioner asserts that that there was no control resolved, I think if we read the contract in its entirety, the contract does say, T&D is the independent contractor and they have control over the means. I'm not arguing that it doesn't say that. But what I'm saying is there are exceptions to that control that the contract specifically lays out. And 2 exceptions that the Supreme Court looked at, that the Court of Appeals looked at, were number 1, whether or not the presence of an on-site personnel, could exercise control, and number two, the requirement of remediation. And then, but I think that there's a
Just
couple
to
of,
clarify, the
Yes, Your Honor.
on-site personnel, that is a T&D person that's designated to take direction from AEP. It's not an AEP person on site. Is that right?
No, Your Honor, I believe it's an
Okay.
AEP person on site.
Okay. So there is an AEP person on site, but not in this case in particular, but in general.
Yes, Your Honor,
Okay.
that's correct. And at the point where AEP has the opportunity and the power to submit things like change orders or to change the scope of work, and if T&D and AEP should somehow disagree about the scope of those changes or the way that the work has changed, well, the contract specifically says that T&D has to listen to AEP. So in cases like that, it's almost like if they give an instruction, that instruction must be followed. And at that point, there is no discretion for an independent contractor to do the job, as the court says in its case law, as it sees fit or as it deems fit.
To Justice Bland's point, I think the provision might read, T&D shall have an authorized representative at the site to whom AEP may give instructions at all times when work is being performed. But if that were the case, I understand you disagree with that, but if that were the case, does that change the analysis?
I don't believe so, Your Honor, because whether or not there's a T&D representative on site or an AEP representative on site, the contract specifically reserves the right for AEP to make any changes that it wants, and that T&D has to accede to those changes. And then additionally, specifically with respect to the kind of job it is, if there's any sort of specific or specialized tools or materials that need to be used, AEP has control over the tools that are being used and how those tools are being used and what processes that they go through with using those tools. So in this particular case, if they needed a special tool to go out there and fill that hole, maybe because of the size of the hole or maybe because that they weren't able to do it with what they had out there, the contract specifically reserved for AEP the ability to designate what kind of equipment to use and the procedures for using it.
Are those just general safety standards? And is that enough to establish, the control?
Well,
We
Your
use
Honor,
that language in Dow.
I agree. Well, Your Honor, I think that's what makes this such a difficult question, because I mean we have cases, like Dow, where where the court found that there was no duty, but the difference between Dow in this case is the type of contractual provision that the court was looking at. In the Dow case, there was a safety manager for Dow who was on site, while Bright, who was the contractor who was injured, was performing construction, and Dow never gave an instruction about how Bright was ever supposed to do his job. In this particular case, it's not a safety person that's there, and they're not there to make sure that no provisions are being violated. Instead, the person that's there is there solely to receive instructions for AEP, and based on those instructions, to tell his own crew what has to be done or what has to be changed. The Dow case and some of the other cases, like Williams or like Gonzalez versus Ramirez, they basically say that you can't have a contractual provision that says you have to follow the safety precautions and safety procedures, and that's enough to reach control. But in this particular case, the person who was on site isn't there for the aspect of safety. They're there because they're supposed to receive instructions from AEP if something has to be changed. And I think that's the difference.
the hole was filled after, was allegedly filled after most of the work had already been completed, right?
Your Honor,
Or
yes,
am I-
yes, but
am I
yes, but
mistaken
no.
some of the dates? Go ahead.
Their allegation is that they pulled the pole and they filled the hole, and those were the only jobs that were supposed to be done that day. That's what they say happened. We say that they definitely pulled the pole because the pole was sitting in Miss Arredondo's yards for 8 months, but we don't think that the hole was filled.
Is your position that AEP, factually speaking, had any control or influence over the way the hole was filled? Or is your position just that they theoretically had the right to control that, and that's where the liability comes from?
Yes, Your Honor. I think they theoretically had the right to control that, because if they factually controlled it, well, then we would be talking about an actual exercise of control and not retain control on a contract. And I think that's the biggest issue, I think, is that if we just make it more and more specific for contractual provisions to specifically relate to jobs, well, then there's no difference between having a specific contractual provision talking about a specific aspect of the job and an actual exercise of control. I think at that point, they're almost identical.
If it's purely the theoretical right to control, then I'm having trouble imagining a situation where the general contractor would have this protection, because the general contractor is always ultimately in charge of the job, and in theory can, no matter what the contract says, is always going to be able to assert that influence. I mean, I suppose you could imagine a contract that says the general contractor can't interfere with the independent contractor, but it's hard to imagine anybody signing that. So what's a real world example of a way where this protection could actually accrue to the general contractor if the mere theoretical right to control is enough to overcome it?
Yes, Your Honor. I think going back to the Dow versus Bright case is pretty instructive, because in Dow versus Bright, there was a specific contractual procedures that contractual clauses that said that the independent contractor was solely in control, just like they are here. But it also said that any provisions that appear to give Dow the right to direct the details shall be deemed only to mean that the independent contractor shall follow the desires of Dow in results only. So the contract actually specified that if we try to change it or control it at any time, we're only really talking about the end result. And what AEP would have the court read is basically to read this language into language that's not within the contract. They want the same result in Dow versus Bright in Arredondo as they would in Dow versus Bright. But in Dow versus Bright, the contract specifically said, hey, it may look like we're directing the details, but we're really not. We're really concerned about the end result. And they've made that argument here in their brief, but the problem is it's not specifically within their contract. And I think that's a very distinguishing factor.
Let's say there is no contract, and I just go out and grab somebody to be my independent contractor and do some work for me. Would the default rule, you think, be that I control them, or not? I mean, what's the default rule against which you're contracting as to whether the general contractor has the right of control?
Well, Your Honor, it would depend on what you told that person to do at the scene. I mean, if you said, hey, I need some help cutting my lawn, and I'm going to cut the front half of the lawn, and you're going to cut the back half of the lawn, or I'm going to cut the lawn and you're going to weed eat. Well, if somebody gets,
please mow my yard.
Sure. Well, it depends. If you ask someone to mow your yard and you don't give them any other instructions, then yeah, they're an independent contractor and you haven't asserted any control. But to the point which you say,
don't I have a right to control? I can walk out of the backyard and control him. I always theoretically have the right to do that.
Yes, Your Honor. You could go out there and you could say, hey, can you you missed a spot there, or hey, can you cut it shorter? But that's not the same as going out there and saying, hey, I don't like the way that you're doing that, and I think you should do it this way. At that point where you're taking more of an active role in it, I think you're exerting the control, the sufficient control. And in this case, it's not a contract. It's just the actually what happens. I think you're at some point asserting sufficient control for you to have some liability.
Mr. De Vera, what's your response to the cases that opposing counsel cited saying that our cases require that there be an explicit assignment of control to give rise to a duty? She mentioned the Victoria Electric case specifically.
Yes, Your Honor. I think the Victoria Electric case is factually distinguishable because Victoria Electric occurred when they were transporting utility poles from one site to the installation site. And the Court of Appeals specifically said, that there's not a nexus between their contract and what they contracted the transport company to do, and the actual driving of an automobile from one site to another. And in this particular case, it didn't happen off a job site. In Victoria Electric versus Williams, the incident happened outside where the relationship between the contractor and independent contractor was occurring. In Arredondo, it happens on site. And I think that's something that's distinguishable, because certainly if you if you told me to transport something and you watched me load it, but then something happened on my way there, it's not, there's no nexus between what you actually hired me to do and what happened and what caused the injury.
So I appreciate that on the facts, but does that, what about the legal stand? What is the legal standard for how much control you have to retain and how specific the provision needs to be?
Well, in the Williams case, I believe that there were safety manuals from Victoria Electric that told Urban what they needed to do with regard to loading the poles. But I think that the Court of Appeals looked more at whether or not there was a nexus rather than whether or not there was sufficient control. I think the Court of Appeals said that under a different set of circumstances, there may have been an exercise of control. And I just think that the circumstances here are different enough that making and having an authorized representative on site to take instructions and to change the job as necessary, and also having the immediate requirement that property be immediately repaired or remediated. I think those are close enough to where they would control the actual details of what the contractor could do. So for example, the contractor, couldn't do part of the job, leave, and come back and finish the job later. The contractor would have to stay there and was obligated to repair that premises and not leave until it was done. And then having an on-site representative at the scene, if there was any kind of order or any kind of change or any kind of change in scope or change in work, they were directed to do it immediately. I hope that addresses your question, Your Honor. And so with regard to AEP, we think that the Court of Appeals properly found that there was an issue of retained control based on the way that those contractual provisions were written and in reading the contract as a whole. Now, if we move past the issue of no duty, then the question becomes, well, how are we going to analyze the type of duty and what are the elements to analyze in this kind of case? And I think that's where the law gets interesting, because I agree with Ms. McCormick and what her briefing is. There's a very strange intersection between general liability and premises liability and vicarious liability that's there. And I think that the factor that determines what you apply is what kind of, whether or not, first of all, who it is that you're suing. And second of all, what was their relationship in regards to the property. And I believe it was Justice Lehrman, or maybe it was Justice Guzman that asked, well, isn't this an unusual situation because Miss Arredondo is also the property owner? And that's exactly right. She's the one in control and possession of the property. And if she's the one in control and possession of the property and we're bringing claims against AEP, we can't bring premises liability claims. They have to be general negligence claims.
And so she's not just in control and possession, she's the owner of the property. And
Yes,
so it
Your Honor.
makes it very, very different. And so do you know of any authority that allows a premises liability suit in this type of situation?
Your Honor, I wasn't able to locate anything with facts even similar to this. This might be a case of first impression, but as if you want to require me, just like you did with Mr. Shepard, to submit post-motion briefing, I don't mind doing that. But it's just a very unusual question because the type of utility interest that AEP had is not a possessory interest. I'm sorry, I'm not here. There we go.
All right, I was muted, sorry. Any other questions? Thank you, Mr. DeVera.
Thank you, Your Honor.
I believe there are 4 minutes left for rebuttal. Ms. McCormick.
May it please the court. I just want to clarify, if it's not already clarified, that this contract provision that we've been discussing does not actually require AEP to have a supervisor or anyone on the premises. It requires T&D to have someone on the premises, and the purpose is so that AEP may choose to give instructions, but that provision does not specifically pertain to means, methods, and details or operative details of the task. That's what's missing from that provision. And even if you perceive that there is a gap somehow, or that it's possible that AEP may, there's a theoretical possibility that AEP could give instructions about the operative details of the work under that provision, you can't assume that will happen because of the other provisions that I outlined already that make clear that T&D is responsible for supervision of its employees, direction of its employees, and choosing the methods that are safe and protect the public. I also wanted to briefly discuss the other provisions that Mr. De Vera referenced in his brief and briefly in his argument. The Court of Appeals actually got that right. Those other provisions there's no nexus between those and the actual task that was done here. And so the law is clear that there must be an actual link, a logical link between the contract provision and the actual task and injury for control to arise under this theory. And it sounds as if Ms. Arredondo is actually arguing for traditional master-servant liability, the kind of duty that arises in an employer-employee relationship. But that's not what they alleged in response to AEP's motion for summary judgment, and it has never been what they've actually argued in their briefing. They are solely relying on this theory of retained control under Section 414 of the Restatement of Torts. That is fundamentally different from the type of liability that arises in a typical master-servant relationship. If the provisions that the Court of Appeals relied on here give rise to a duty or potential liability, then you are essentially writing Section 409 out of the Restatement of Torts. Section 409 is the one that says general contractors are not liable for the acts of independent contractors. Section 414, retained control, is an exception to that general rule. It's clear under Texas law that general supervisory provisions are not enough to give rise to a duty under Section 414, and neither are contract provisions that merely control the result of work. And that's the second provision that the Court of Appeals relied on and that Mr. De Vera was discussing. The provision that requires T&D to restore private property immediately after work is a wholesale delegation of control over that work to T&D. And to say that the delegation of that duty to T&D gives rise to a duty in AEP is just contrary to all of the cases, including Dow Chemical versus Bright, which has already been mentioned several times today. That provision only dictated the results of T&D's work, and the other provisions I mentioned make clear that T&D decided how to do the task, and the Court of Appeals just didn't mention those, much less give them effect. We would respectfully request that you reverse the Court of Appeals judgment and render judgment that Arredondo take nothing.
Any other questions? Thank you, Ms. McCormick. The case is submitted. That concludes the argument set for this morning, and the clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.